Hi, I'm Dr. David Scott. Welcome to Senior Seminar Review for Criminal Procedures. First, let me congratulate you on your senior year and your upcoming graduation. What we're going to do in this module is we're going to review some of the highlights from our criminal procedures course in the criminal justice program. So, starting right off the bat, we do remember that we do have the court system, court cases, and sources of our rights. Now, in the United States, we have what we call a dual court system, which is basically federal courts and state courts. The court decisions are binding only that the courts in the court's territorial jurisdiction. Some criminal cases can be tried in both federal and state courts, and the concept of double jeopardy does not apply there. Meaning, if you violate a state law, for example, in the state of Texas, and it turns out that that violation also intrudes into federal law, we can try you in both cases. For example, if someone was in possession of, I don't know, child pornography, all right? In Texas, with 6 or more identical pics, it's a felony to have child pornography in your possession. In fact, with 6 or more identical pics, we bump it up to the next highest level, which proves the intent to distribute. Now, we can prove in court that typically most child pornography is not generated within the jurisdiction of the state of Texas. It had to come from overstate, sometimes overseas and other countries, and it was downloaded into a computer or a thumb drive or a cell phone. Therefore, we would have the option to basically try you at the state level first, and then also try you at the federal level. Now, the distinction between jurisdiction and venue is something else we're going to talk about in just a moment, and we're going to talk about the 4 sources of our legal rights, as well as define the term of the rule of law here for this particular section. Now, the United States, as I mentioned earlier, has a dual court system. One system, again, is for federal cases, and the other one is for the state cases. The federal court system is defined under Article 3, Section 1 of the United States Constitution. Now, the highest court in the federal court system is the United States Supreme Court. They decide cases on what they call as an en banc, means one body. It's a term you need to remember, where they basically look at an issue and they have a collective vote of 9 justices up there, and the majority usually wins. Now, the court has original jurisdiction. When I talk about the court, I'm referring, of course, to the U.S. Supreme Court. The court can hear cases on appeal, writ of certiorari, certification, which seldom ever happens, and a writ of error. Now, these writs are just basically mechanisms or tools to get a case in front and heard before the Supreme Court. The most common one is the writ of certiorari, meaning that they basically send it through the appeals court, it's at the Supreme Court, and there's an error in the decision or an error in the trial that they want to have the court interpret to see if it was in fact an error or something else that they need to look at. The Supreme Court jurisdiction also has what they call the rule of 4 in writ of certiorari cases, meaning that in order for them to hear a case that's sent up under this mechanism, typically 4 of them have to agree to hear the case. Now, there's some terms here in this section that I just want to remind you and review on real quick. First, state courts operate very similar to federal courts in terms of being set up. Now, there was a term stare decisis, and it was a Latin term meaning to abide by, to adhere to, or decide cases. Meaning that if we had a case and it's already been heard, or we've had cases go through in the same manner in the same instances, then we basically would stand by and let the decision stand with the original case and not have to rehear a case over and over again. We have what we call judicial precedent, which means that the decisions of courts have to have value as precedent for future cases with similar circumstances. So in other words, unlike stare decisis, if we have a case of similar situations, it's driving while intoxicated, and the officer in one city stops the driver who's drunk or suspected of being drunk, and then it happens again in another city. Well, the procedure and the way each officer handled that case in terms of making contact, doing standard sobriety tests, writing the report, and filing the case is generally the same. Then we have a concept called judicial review. The power of any court to hold unconstitutional and hence unenforceable any law, any official action based on a law, or any other action by a public official that it deems in conflict with the Constitution is basically subject to judicial review. Now, judicial review was first brought about in the historic landmark case of Marbury versus Madison in 1803, another important case from the course. We also discussed earlier the difference between jurisdiction and venue, and a lot of students get these terms confused or they use them interchangeably, and that's simply not correct. Jurisdiction is simply the power of a court to try a case. You try a criminal case in a criminal court, a civil court case in a civil court, and so forth. Venue is the place where the case is actually tried. If it's in your county, if it's in your city, if it's, say, in Smith County or Gray County or Upshur County or Travis County, that is the venue. We also have the concept called rule of law. Now, this is difficult to define, but it generally means that no person is above the law, and that every person, from the most powerful public official down to the least powerful individual, is subject to the law and can be held accountable in the courts of law for what he or she does. Basically, going back to that old symbol that justice is blind. We don't care how rich you are or who you are, or if you're completely indigent and you're homeless. Everyone basically should be held to the same standard if they are brought to trial and if they break a law. Now, reviewing even further, the Bill of Rights. What were the Bill of Rights? Well, they were the first 10 amendments to the U.S. Constitution. These are the minimum rights individuals have when they're facing criminal prosecution. So just some of the highlights we talked about on some of the amendments. We first discussed the First Amendment and the provisions for freedom of religion, speech, assembly, and the petition for redress of grievances. The Fourth Amendment, protection against unreasonable arrest, search, and seizures. We'll talk more about that in just a little bit. Those cases came out of Mapp versus Ohio, the most historic one from 1961, as well as Wolf versus Colorado in 1949. The Fifth Amendment against self-incrimination. The Fifth Amendment against double jeopardy, which was Benton versus Maryland in 1964. We had the Sixth Amendment, which is the right to counsel, a very important case, Gideon v. Wainwright in 1963. The Sixth Amendment, the right to a speedy trial, which was Klopler versus North Carolina in 1967. And the Sixth Amendment right to confrontation of opposing witnesses, which was Pointer versus Texas, an actual Texas case in 1965. Also, the Sixth Amendment spends a lot of time with the rights of the accused. Furthermore, the Sixth Amendment has the right to confrontation of opposing witnesses, as I mentioned earlier, Pointer v. Texas. The Sixth Amendment right to an impartial jury in Duncan versus Louisiana. The Sixth Amendment right to the compulsory process for obtaining witnesses. And the Eighth Amendment prohibition against cruel and unusual punishment, which was Robinson v. California in 1962. So when we look at the overview of the criminal justice process, and it is massive, from the minute we make an arrest, going to the jail, doing the bookend, doing the arraignment, going to trial, selecting a jury, listening to the prosecutor, listening to the defense, hearing closing arguments, deciding on a verdict, going through the sentencing process, filing an appeal, it takes a long time. So what we're going to do is, this is an overview of the criminal justice process. Now, the procedures before trial, before a judge even sees this, is that we have the filing of the complaint. A law enforcement agent, a first responder, or somebody files an affidavit or a complaint, which is basically naming the charges of someone arrested. Then we arrest the individual. We take the individual and we book them into the local jail, whether it's in the police department or in a county jail or someplace like that. After they're in the jail, they have the initial appearance before the magistrate after the arrest, meaning within 24 to 48 hours, depending on the county and jurisdiction, they'll go in front of a judge to hear the charges, and they'll basically set bail. Then they'll set a date for the preliminary hearing. Then the decision over that time by the prosecutor to look at the charges to see, hey, does this guy want to do a plea bargain? Do we even want to take this case, or are we all set to go to trial? If it's undecided or there's just not enough probable cause, there are things that happen. We make a good arrest on site, we do some investigating, and the prosecutor's not quite sure if we have enough to go forward. We have this mechanism called the grand jury. And what the grand jury does is they basically review the facts of a case and then collectively decide if they're going to bill, which means make charges, or no bill, which means don't file charges on that particular case or a particular case. If they decide to bill, what they're going to do is they're going to set up a date and time for this person to come to trial. There's going to be an arraignment. And at that point, like you've seen on TV, like Law and Order and all these other cool cop shows and court shows, where they stand, dressed up and cleaned up next to their lawyer, and the judge says, all right, we're here to see the offender or the guilty person. How do they enter a plea? Guilty, Your Honor, not guilty, Your Honor. And then if they say guilty, but we set up an arrangement for a plea bargain, meaning they confess to some or all aspects of the crime and in the possibility of a lesser sentence. Now, let's say it does go to trial. Now, during trial, again, that has its own procedures. And what we're looking at here is first we have to select a jury of reasonably free-thinking people, jury of your peers under the Constitution and Bill of Rights, and that process is commonly known as voir dire. Basically, in every county, a lot of people get jury selections or summons. They show up to a courthouse, they sit in a giant room, and then from there, we're kind of whittled down into clusters of 12 or 18, depending on the type of trial and which court needs jurors. After the jury is selected, we have the opening statements by the prosecution informing the jury and the court about the facts of this case. Then we have opening statements by the defense, the one representing the guilty party or the person you arrested. And they're basically to open their statements to say, hey, this isn't what happened, my client's been wrongfully accused, the facts don't add up, there wasn't probable cause. Then they present the case by the prosecution, and then their case is presented by the defense. So it kind of goes back and forth to keep those scales of justice as even as possible. They can both enter rebuttal evidence, meaning that, well, I have an expert here, well, I've got an expert on this side, and they can challenge the expertise, they can challenge the submission of evidence, what they call a suppression hearing. And then after all this is done, and we've basically laid out both cases and we've heard all the facts, both parties, the prosecution and defense, engages in what they call closing arguments, which is just a summary of the facts for their case, the strengths of their case, the weaknesses of the other sides, and then they basically stop. Then they go into motions prior to the verdict to submit any last-minute evidence, challenge anything that might have been said or things that need to be addressed before it goes to the jury. The judge then instructs the jury on what they can and can't decide on and gives them the facts of the case and basically redefines or re-explains their role as a jury. Then we have what we call jury deliberation. And what happens there is the jury steps out of this, they go into what they call a jury room, and they basically decide on the facts of the case, guilt or innocence, how much to award in a civil case, and so forth. In a criminal trial, the only verdict that they come back with is guilty or not guilty. And then they explain the reasons for both. Now, the procedures after trial, some things can happen. If they are found guilty, they have what they call the sentencing hearing. And this is where a judge looks at the facts of the case, looks at the jury's verdict, and then that judge typically decides how long this person will either go to prison, go to jail, how much they'll pay in fines, or if they have community service or something like that. If there is a problem or in a process during the process of the trial, or the defense feels like it wasn't a fair trial, they can file an appeal. An appeal means that we're not deciding guilt or innocence just quite yet on the client, but we're saying during the process there were some problems that basically went against the law, the prescribed law, or interpretations were misread by the judge or somebody like that, and they want the case reviewed by the next higher court, which is the appellate court. They will review the transcripts. They're not going to retry the case. They're not going to hear anything directly from the defendant, prosecution, or defense attorney. And then they're going to look at it. If there's a problem, they'll kick it back for retrial, or they'll say, nope, we affirm and we believe that the trial court did everything correct. If they're still not happy, they can file what they call a writ of habeas corpus. And habeas corpus just means the body of, meaning the body of the defendant, bring them immediately before the court or magistrate to plead their case as to why they should be either retried or set free or something like that, and that happens all the time. Now, getting away from the courts for a minute and going back to law enforcement, there are two very important concepts we spent a lot of time talking about. One was probable cause and the other one was reasonable suspicion. And probable cause and reasonable suspicion is the backbone of an officer, special agents, or anyone in law enforcement's decision-making at the time prior to an investigation, during an investigation, or if they're going to make an arrest or detain somebody. So loosely, probable cause is defined as this: the facts or circumstances within the officer's knowledge and of which they had reasonably trustworthy information that are sufficient in themselves to warrant a man of reasonable caution in the belief that there has been or a crime is being committed. All right? That means under all intents and probable circumstances, I don't need complete beyond reasonable doubt, but if I had 6 or 7 people standing next to me and they came to the same conclusion that a crime was being committed or about to be committed, you have probable cause. Now, I kind of made that short and sweet, but probable cause also exists when there is more likely than not more than 50% certainty that something's going on, and that the suspect committed an offense, or that the items sought after can be found at a certain place. You may want to get probable cause to go search for stolen items, drug paraphernalia, weapons, child pornography, or a person or suspect themselves. Now, in the absence of probable cause, the act is illegal and the evidence obtained must be excluded by the court. Meaning that if I go in someone's home without a warrant, without consent, I have no probable cause, this person just looks like a dope dealer, and I've dealt with this person before, and I'm pretty sure there's dope in there because people are coming in and out every 30 seconds, and I kick in the door and I just basically put him at gunpoint, and I see cash and dope and drug paraphernalia all over the house, and they may even have a meth lab in the kitchen. Awesome. That's great. I'm stopping crime. The problem is I went in there illegally. I went in there without any probable cause, so everything I just did is going to be thrown out at court. It's not going to be admissible. Now, probable cause cannot be established by what is found after an illegal search or arrest, meaning that probable cause has to come first before the action. Now, we can establish probable cause in 3 ways. Number 1, the officer's own knowledge. I saw something, training and experience, right place, right time, we act on it. If I have information given to the officer by an informant, somebody we trust who doesn't have a dog in that fight, someone who's given us credible information before, or it could just be a third party who says, hey, I'm average Joe citizen, I saw this, it looks suspicious, you want to go check it out. That's when we move into information plus corroboration. Meaning that let's say we illegally or we unlawfully detain someone or arrest them and we cut them loose and then later on they come back and confess the crime. Even though initially our stop, detention, or arrest was illegal, the fact that they voluntarily came back and under free and voluntary not compassion, but expression basically told us that, yeah, I did it, I feel bad about it. We can use that for an arrest to build probable cause, or probable cause to build arrest. Now, when in doubt, the old saying in law enforcement is obtain a warrant. Now, here's the benefit of having a warrant. Number 1, it's based on probable cause. You explain to a judge or magistrate why you believe so-and-so is somewhere or so-and-so needs to be arrested, or at this location, all this good criminal items and criminal stuff exists. You have to explain it, which means you've done your homework, you wrote it up, you're going to take an oath and affirmation swearing that everything in that document, that arrest warrant or search warrant is true and to the best of your knowledge, and you're in good shape. Now, it is also a good defense in civil case for damages, meaning, well, my car was worth $1 million and it was a $4,000, 1984 Toyota Celica, and you describe the vehicle, you have the VIN number, and we can look all that up. The search warrant or the warrant itself has a lot of details that just covers your officer. So where does probable cause fall with reasonable suspicion? Probable cause can be compared to other levels of proof. At the top, we have clear and convincing. Probable cause falls underneath. Below that, we have reasonable suspicion, which we'll get to in a minute. And then below that is just a small, tiny little bit of suspicion called mere suspicion. Now, reasonable suspicion is defined as the quantum of knowledge sufficient to induce an ordinarily prudent and cautious man under similar circumstances to believe that criminal activity is at hand. All right, now reasonable suspicion is lower in certainty than probable cause, but higher than mere suspicion. Meaning, you don't have cause for arrest, but you know something's going on, so you're going to stay here and watch a little bit longer, you're going to do some more investigating and build those blocks to get you probable cause. Now, determination of reasonable suspicion must be made in what we call the totality of the circumstances. And there's a reason when you see these bold words is to jog your memory. Totality of the circumstances is the big picture. It means looking at everything under these circumstances that would either make you act to make an arrest or do an investigation, or you simply don't have it if the totality is not there. Now, taking into account an officer's knowledge and experience, that also builds on the totality of the circumstances. Do you have the right charges? Do you have the elements? Do you have a lawful reason to be there? Did you need a warrant? Did you have consent? Stuff like that. Now, reasonable suspicion is initially determined by the officer, but reviewable by the magistrate, trial judge, and appellate court judge. Meaning that, yes, officers are given reasonable suspicion to act on, but here's the rub. It's going to be critically examined later, before, during, and after trial. So for something that took you 30 seconds to decide or a millisecond to decide because you had reasonable suspicion, is going to be critically reviewed and analyzed over several months or even years by other people who weren't there and that are going to be going from case precedents or what I like to call armchair enthusiasts, where they're sitting from the chair and they think they know everything, and then just basically either support or try to negate your actions. Now, reasonable suspicions can also be compared to other levels of proof. Reasonable suspicion is a lower probable cause. It's lower than probable cause, but again, mere suspicion, which I don't spend a whole lot of time talking about in this class, in an officer's decision. Mere suspicion means you see something, it doesn't look right, and either you turn around and try to get it so you can get more reasonable suspicion to watch or probable cause, or it wasn't significant enough for you to stop, so you keep driving by and you'll come by later and see if something's still going on. That's the best definition of mere suspicion I can come up with. Now, let's shift gears for a minute and talk about the exclusionary rule. We talked about this at great length, and we had some attorneys come in, we had some FBI agents come in, and other officers who brought up the exclusionary rule. The exclusionary rule states that evidence obtained by the police in violation of the Fourth Amendment right against unreasonable search and seizures is not admissible in court. All right, now the purpose of the exclusionary rule was not so much to protect the victim per se, but it was more to deter police conduct back in the day. Now, the exclusionary rule is a judge-made rule designed to protect the Fourth Amendment right against unreasonable search and seizures. Meaning back in the 60s, 50s, and sometimes even today, officers get kind of liberal in their searching. They're in a house, they see things, they start arresting folks, and then all of a sudden, once the person's arrested, they start looking in drawers, they start looking in cabinets, they start looking under beds and stuff like that, or they start going through people's computers and all that. Well, the trial court and the appellate court and even the U.S. Supreme Court is going to say, hey, wait a second, you arrested this guy on this warrant. What gave you the legal authority to go through his house and look for other things that were not in plain view? And we're going to talk about plain view in a little bit. The rule of thumb is we should have backed out and got a warrant if we had probable cause. We can't go on these fishing expeditions anymore. The courts are coming down on us and telling us absolutely that is inexcusable. Now, the exclusionary rule excludes two kinds of evidence. Those that are illegally seized, meaning I had no reason to be there and take them and I just took them anyways, or those from the fruits of the poisonous tree. Or if you all remember from our discussions, the fruits of the poisonous tree doctrine. And what that basically said or stated was if I'm going through the process of gathering things illegally, I'm looking through your computer without a warrant or consent, I'm trashing your car, I'm going through your apartment, and then all of a sudden I stumble on something illegal and charge you with it, well, my initial contact and my initial reason for being there was illegal, so everything after that, basically the fruit that was bared from this investigation, is poisonous and therefore inadmissible in court. Now, the biggest case you guys probably need to remember in this section is Mapp versus Ohio. Go back and review that. But it basically applied to the exclusionary rule to state criminal cases. It's a very important case that was in 1961. Now, there are four generally exceptions to the exclusionary rule. We have officers acting in good faith. I had a legal reason to be here. I wasn't looking for A or B. As I got into the apartment, I got into the hotel room. As I'm looking around, I find A and B. I pick it up, take it with me, and charge you with it. I wasn't looking for it. I just stumbled upon it. It was just good investigation. Inevitable discovery. If, say you go into, you guys know in Texas, it gets hot. And let's say that we have a missing person or we have a dead body or something like that. And I've had lots of those. The only time of the year I really hated it was from like May until August because houses get hot, especially if there's no air conditioning. Inevitable discovery would be the smell of the body. Or it would be me walking by a window and seeing someone lying in there or seeing something in plain view that basically, well, we were here, we were inevitably going to search this room, we were inevitably going to search this house, we were inevitably trying to make contact with this person. Stuff that's purged and tainted, or an independent source that says, hey, basically, you know, let's say, for example, the best example. Let's say we know that there's stolen property in a hotel room. All right, we knock, he doesn't answer, we play that game a few times. Finally, he does not put out a do not disturb sign, so the maid service goes in. And the maid, hey, we stop the maid service and we say, hey, look, before you clean this room, go in there. If you see anything illegal, back out and tell us what you see. Well, that would be wrong because I have basically directed that person to act as an arm of law enforcement to go in there and do something under investigative purposes. However, if that person went in there and we never talked to that person and they go through cleaning the room and they see guns and child porn and drugs and stuff that looks suspicious, and she does her job, backs out and calls the police and then tells us, we're good to go. All right? So basically it all goes back to our intent and how we went about getting that evidence. Now, we also talked about stop and frisk and station house detention. The 5 important cases that I really want to stress in this section that you really need to go back and review is Terry versus Ohio, which was the pat-down test. We had Florida versus Royer, but we also had Minnesota versus Dickerson, which was the squeeze test, where you're patting down the outer clothing and then you squeeze something and you think it's a knife, it could be drugs or a weapon or something like that. And from your senses and your training and experience, you think they might have contraband, and then you build your investigation from there. We also briefly talked about Pennsylvania versus Mims and Illinois versus Wardlow. Just be sure you go back and look at Terry versus Ohio and Minnesota v. Dickerson. Very important cases. So what's the difference between a stop and a frisk? A stop is a police practice whereby a person is stopped in public and questioned. I see someone walking away from something suspicious. There might be a witness to, hey, come here, stop and talk to me. We have a conversation. Now, they're free to go anytime. They're not under arrest. If they don't want to talk to me and I've got no legal authority to stop them or detain them, they can keep walking. That's fine. A frisk is a pat down for weapons, meaning that everyone I stop and talk to and come in contact with, they're a potential threat to me, or they were a potential threat to me or to an officer. So what I'm going to do is just pat down the outer clothing, any place where they could conceivably have a weapon on them. For ladies, it's right here. For men, it's around here, up and down the legs, pant legs. If they got boots, I usually have them boots out and shake it, make sure a gun or pistol doesn't come out. But they are two separate actions. Now, each must be based on reasonable suspicion. I can't just haphazardly go up to a street corner and this guy doesn't, look right. I can talk to him. If he starts putting his hands in his pockets or does what we call a furtive movement, which is suspicious, I can pat him down. Now, stop and frisk are authorized by law and court decisions, so we're good to go on those. Now, a frisk also has one purpose, and that's basically simply to protect officers. That's why we have it. A frisk for any other purpose is going to be illegal. So every time when I was a sergeant or a detective and I was reading officers' reports and I saw the word frisk, I needed to see somewhere in the sentence or in the same paragraph, known felon, known armed subject, not making eye contact, very evasive, thought about running, had to chase him, whatever, to basically show that that officer engaged in that action of a frisk for his or her own safety. Now, reasonable suspicion, as I mentioned earlier, is less than probable cause, but more than mere suspicion. I'm going to keep saying that to hammer it into your heads. It must be based on specific objective facts, meaning would a free-thinking, prudent, cautious person, human being, generally come to the same conclusions you came to at that moment if they were put in the same situation. That's typically my threshold test. Now, there are two limitations on a stop. Number one, it must be temporary and no longer than necessary to achieve its purpose. If I'm stopping a car and I don't see something, I don't smell something, the driver has no sense of alcohol, eyes aren't bloodshot, he's not slurring their speech, and it's for traffic, if it's for speeding, I'm either going to write him a ticket or just tell him to slow down. I can't search their car. I've got no reason to. Now, I can ask and say, hey, do you mind if I search your car? And he's like, oh, yeah, sure. I love having my car searched. And he gets out, sits down, and I tear his car up. He's cool with it, and so am I. Chances are when that happens, I'm never going to find anything. Now, occasionally someone will say, yeah, you can search me. And then they say, well, yeah, I've got dope. Yeah, I've got a gun. I just don't want to fight you. You're cool. You're being nice to me, blah, blah, blah. I've actually had people thank me for that. The second part of this is it must be least intrusive action available to the officer, meaning I can't do a body cavity search, nor do I ever want to do that to somebody. I can't do a strip search on the side of the road. I can't, have someone stick their fingers down their throat and start throwing up pills or drugs or something they swallowed right before I got there. That's going to require a warrant and a lot more paperwork. But I can pat them down for weapons. I can ask them politely to empty out their pockets, if I can go through their purse, backpacks, and stuff like that. And we're going to get into motor vehicle searches in just a minute. Now, motor vehicles can be stopped only if there's reasonable suspicion of possible involvement in unlawful activity by its occupants. They may be frisked only if there's fear for the officer's safety. If I'm driving around my area and I've been on this beat or this zone or this district for 5 years and I see a particular car and I know it's got bad people in there, up to bad things because I've arrested them 100 times and I know that car, I can articulate my officer's safety. All right? I can articulate not only did I stop them for a traffic violation, but I basically pulled one out at a time, patted them down, searched the vehicle for weapons or dope because they're known to do this. Some of them might even have city warrants or what we call capious warrants. And go, for my safety, this is why I did what I did. I'll never get in trouble for that. Now, a station house detention or bringing them back to the police department, either to fingerprint or typically now it's the county jail, or if I'm going to do an interrogation. I'm going to talk to a suspect and basically corner them and lock them into their story and try to figure out why they did this crime and try to get a confession. Both of them, regardless, are subject to Fourth Amendment protections. Unreasonable search and seizures, the right to an attorney, right to counsel, all that other stuff. We can't just bring them in like you see on TV, fingerprint them and yell at them and scream at them and throw them out windows and stuff like that. Don't do that. Now, the searches and seizures of persons, basically the term seizure is broader than the term arrest. I'm taking something. An arrest is a seizure of a person. If I'm seizing items, I'm taking things for investigatory purposes or you're not supposed to have them. All arrests are seizures, but not all seizure amounts to an arrest. All right, I'm going to give you some examples of that in just a moment. Now, some contacts with the police are also so minimally intrusive, they're not even considered seizures. All right, I've had people where we're walking around the street at night at a party and someone sees us and they drop dope out and they keep walking. And I'm bold enough to say, hey man, you dropped your meth, you dropped your crack pipe, you know? Oh man, that ain't mine. That ain't mine. I said, well, you sure? Because I thought I saw it out of your pocket. No, man, you want to search me, whatever? They're not going to own up to it. I don't care. Now, I could bust them for littering if I wanted to and make a case out of that, but I typically won't. It's too much work. Now, neither the perception of a person detained nor the officer determines whether the seizure has taken place. Instead, the trial judge or jury determines whether a reasonable person under the same circumstances would consider the situation of that seizure. Meaning I've got a few seconds to make a decision, but it's going to be, reviewed for a while by other people. And I've got to be confident in doing what I'm doing, and that's why it's important you know case law, you understand how these search and seizures work, you understand your state law, you understand your policies and your department protocols and guidelines. Now, when you make an arrest, there are 4 elements. You have the seizure and detention of an individual or people. I have to show my intention to arrest. Number 1, are you not free to go? But number 2, turn around, put your hands behind your back. I don't have to taser you, pepper spray you, or fight you. And then I tell them why they're arrested. All right, you committed A crime, B crime, you did knowingly and intentionally do this. I have enough probable cause to believe you did this. And then my authority to make the arrest. All right, in Texas, when you become a peace officer, you have the entire state as your authority, even though you may work in Tyler, Longview, Dallas, or when you're out visiting and you see a crime in another part of the state, you still have the authority, and then we have rules. We have to turn it over to the local authority, in terms give it to the local magistrate and stuff like that. Now, also, we have to be sure that the arrestee understands why they're being arrested. Now, sometimes this is tricky. They're heavily intoxicated. They may have a mental illness. They may just want to play the I don't speak English game, stuff like that, and that's fine. As long as you're doing everything in good faith and above board, we can get a translator, we can take them to the hospital, we can wait to sober them up and charge them later. There are avenues for us. Now, there's 2 types of arrests that we talked about in the course that we deal with. Number 1 is arrest with a warrant, meaning I have a signed piece of paper by a judge who wants this person in trial, in their jail, to stand trial later, and I have no choice. Or I have without a warrant, meaning I see something, hear something, investigate something, I act on it immediately because there's no time to get a warrant, or it's something that occurs in my presence, I don't need a warrant. All right, I'll go back and file the charges after this person's in jail. Now, after an arrest, the police may search the arrestee in the area of immediate control, which would be Chimmel versus California, and we'll talk about that later. The general rule is that the police must knock and announce before making an arrest. Now, this is a rule, meaning it's not a law, because in sometimes there is the element of surprise we need it on our side. For example, back in 2005 to 2007, many of y'all know I was on the department SWAT team. There were times where we would hit a drug house or somebody that we knew was going to run or shoot at us, where we didn't have to do the knock and announce. We could just hit the door, and as we ran through the door frame, we all said the same thing. Police, get down, police, get down, police, get down. And you heard like 12 times, but we all announced it after the door was breached and after we could make entry to basically have the element of surprise on our side. Now, the rules for police and using deadly force and non-deadly force differ by state, but generally there's a universal rule that we all adhere to no matter where you are. The use of deadly force is the force that rises to the amount of force you have to use to defend yourself or defend a third person. Meaning if someone's just screaming at me, I can't get all upset and ticked off and just shoot them, all right? If they basically point a firearm, a rifle, gun at me, and I feel that I'm in danger for my life or I'm protecting someone, another officer or a family member or somebody like that, I can respond with the same amount of force, all right? And I can order them to drop the guns, or if there's no time, I just put 2 rounds in them. If they start fighting me, I can respond with the immediate level of force to stop him, but nothing more, okay? And we don't want to be punitive, and that's this 4th bullet. We're not going to be punitive, meaning that once you're in handcuffs, I'm not going to hurt you. I'm not going to touch you. Once you're contained and under control, I don't need to taser you, pepper spray you, or do anything like that. Now, in response to the events of 9/11, September 11th, 2001, the United States passed several laws, and one of the most significant laws we passed was the U.S. Patriot Act to basically counteract terroristic threats and terroristic activities, both domestically and internationally. And overnight, we basically initiated the law creating the Department of Homeland Security, where we took most of our federal branches, put it under one umbrella so we could start communicating and cross-training and being able to respond to more international related threats more efficiently and effectively and save lives. Which brings us to this part. the search and seizures of things of electronic surveillance. Now, the Fourth Amendment and the right to privacy are the two constitutional rights limiting the powers of the police in search and seizure cases. A reasonable expectation of privacy exists when the person must have exhibited an actual expectation of privacy. They go into a restroom and they lock the door. They go into a changing room. They go into a club, and clearly it says no photography beyond this point or strictly prohibited by this point. An expectation that any reasonable person would be like, yeah, I went to the bathroom, I shut the door, no one was going to see me do my business, whatever. Now, the expectation also must be one that society is prepared to recognize as reasonable. So there's two kinds of seizures when we look at search and seizures. Number one is with a warrant, which is general rule. If I need to seize property and I have all the time in the world to get it, I want to get a warrant. This covers me, covers my agency, and the legality of the seizure. Without a warrant, this is the exception, meaning that if I'm knocking on the door and all of a sudden I hear people, deleting files, and I don't know what that sounds like, but trashing the house, flushing drugs down the toilet, beating someone up, or threatening to shoot them, we have what we call exigent circumstances, which simply means there's no time to get a warrant. I need to get in there and either preserve the evidence, arrest the bad guy, or save the victim. Now, some types of seizures don't need a warrant. One would be incident lawful to arrest, meaning that I legally arrest someone, whether they have a warrant or I caught them doing something, and as I'm searching that person for weapons, contraband, I'm taking their property away from them, we're going to give them back to the jail, and I stumble across something, I'm good to go. If someone, and people have done this, hey, you mind if I search you? Yeah, but I got meth right here, I got crack in this pocket, yeah, I got a big knife, I've got a stolen gun, I just bought it for my own protection. People actually say this. Okay, where's the gun? Keep everything cool, we take it and we talk to them, all right? Searches with special needs beyond law enforcement. I may not be able to see the dope, but I know it's there, or narcotics in a vehicle or something. We may bring a drug dog in. We may have to bring in a robot that basically disarms bombs or something like that. I've talked about exigent circumstances, and then a lot of people don't understand this concept is administrative searches and inspections, meaning that like in a public school, students have this myth or this crazy belief that they have an expectation of privacy in their lockers and in their cars and all that. The answer is you don't. The minute you come on property, the property of a school, for example, or even a particular business, depending on what it is, you give up those rights to be on that property. So if a school administration gets a tip that you've got dope or narcotics or a gun, especially guns now in schools, in your car or on your person or in your locker or in your backpack or bag, they can search it. They don't need a warrant. They don't need police permission. They can do this. Now, going back to all these searches that I talked about, there is what we call the reasonableness test, which governs the scope of the search. If I'm looking for a flash drive or a thumb drive or a gun, all right, I have to look in all places where one could reasonably expect to find something like that. And we use the term, we're not going to look for an elephant in a matchbox. Meaning if I'm there looking for an elephant or something really big like a stolen car, I don't need to be pulling open drawers or looking in little tiny cabinets or getting on someone's computer without a warrant. Or if the warrant doesn't say I can go there, I need to either seize that stuff, stand by and get another warrant, or amend the warrant. All right? But we cannot just go on a fishing expedition looking for crime. An officer may and should search an arrestee's body after an arrest is valid or made. We want to look for weapons, contraband, other stuff like that that could hurt us or other potential crimes. When making an arrest, the officer may and should search the area of the immediate control of the arrestee. This was Chimmel versus California, meaning that we had a driver of a car and we had some passengers in there. And basically the court said after this officer did this, that when they arrested everyone out of the vehicle, he searched the interior of the car. He opened the glove box, looked under the seats, looked between the seat cushions, pulled down the visors. You can tell I'm mentally doing this as if I'm there. Looked everywhere and basically found more contraband. And the court said absolutely. Because in a traffic stop, how hard is it to drop your cell phone? Throw something under the seat, put it between the seat cushions and the armrest or the center console or something like that. That could either be used to destroy, hide, or basically be a danger to the officer, a weapon or whatever. We also expended searches for off-duty officers as Fourth Amendment searches, meaning that even though you're off-duty, all right, and you see something and you act on it, you're still a peace officer in Texas or a law enforcement agent or something like that, or a special agent, you're still covered. You can still do your job. You don't have to run back, put your uniform on, clock in, and go back out and do this. Searches of computers are tricky, but they are related devices that are governed by the Fourth Amendment, but case law and statutes are constantly evolving. Anytime I get a phone or I'd get a phone, a laptop, an iPad, I always got a warrant. All right, and the reason being is if I have possession of that device or that instrument, and I know there's no wireless access where they can't go in, through Bluetooth or through an email and delete and corrupt everything, we put it on the shelf, we'll get a warrant, write it out. Now we're free to do with it as we will. A lot of people get really excited when they see electronics and they start going through it and they start finding child porn and terror plans and all this other stuff, and they realize, well, the court's going to say, why didn't you get a warrant? Where was the urgency? And if we don't have a good answer, like, well, it was time sensitive, it was credible information or intelligence, we had to act on it now, we didn't have time to do all that, judge's like, okay, I get that. But if it's something that's been laying there for weeks or months on end, the judge won't, they'll just throw it out. You'll lose the case. Motor vehicle stops, searches, and inventories was another section. Again, also remember, because vehicles are mobile, there's no need for a warrant or probable cause to legally stop a motor vehicle, but there must be a reasonable suspicion of involvement in criminal activity. I can't stop and search every car I stop when I was an officer, all right? If I saw no seatbelt, great. I could contact you, write you the click it or no ticket type of violation. I could ask for consent. Now, if I saw something, I smelled something, I ask you a straightforward question, yes or no, and I'm getting an essay and you're stumbling and you're repeating yourself, I smell alcohol, I see alcohol, I can get you out and then proceed with my investigation. Now, reasonable suspicion, again, is determined by the totality of the circumstances. It's 3 o'clock in the morning, this person's swerving all over the road, he doesn't have a seatbelt on, I look down, he's peed on his pants, I can smell alcohol on the shirt. Obviously, he's operating, I'm suspecting he's operating a motor vehicle while intoxicated. We get him out, we do a test, field sobriety test. He fails them, I put him under arrest for suspicion of driving while intoxicated, and then I can do one of two things. I can ask for his permission to search the vehicle, or we do what we call an inventory. An inventory means I'm going to tow your car, but by law, I have to inventory everything that's not attached or fixed to the car and put it on an inventory sheet. And when I'm doing that, I always stumble across drugs, more alcohol, stuff like that. Another trick we had in law enforcement was roadblocks, and they were for specific purposes. They don't need reasonable suspicion, but roadblocks for general law enforcement purposes are what we call are deemed unconstitutional. Meaning, if I want to do a sobriety check and I want to shut down University Boulevard here on campus, I'm good to go. The rule is I have to stop and do the same thing for every vehicle. I can't just single vehicles out. I can't go looking for dope. I can't go looking for guns. I'm there to look for alcohol. If I get consent, great. If I don't, have a nice day. That's how that works. Now, after a valid stop, we can do several things. We can get the driver out of the vehicle for safety. We can order the passengers out one at a time. We can ask the driver to produce proof of license and proof of insurance in Texas. We can ask the drivers and passengers where they're going, what they're doing, how they know each other. We want to do that separately to see if anyone's lying to us. We can run the vehicle VIN number, which is the vehicle identification number, the license plate, see if it's stolen. We can test to see if the test for drunkenness or impaired driving, whether they're under the influence of something. We can also search the passenger compartment for weapons or if there is reasonable suspicion to do so. And we can search with consent. If the driver says, go ahead and search my stuff, I don't care. Great. Stand right over there. Now, here's the thing about that. They have to be able or be free to revoke consent at any time, saying, all right, man, I got to go to work. I'm done with this. We're done. Kill it. If I don't find anything, I either write him a ticket, thank him for his time, or send him on his way. So that's what we do. Let's see. Vehicle searches. Warrantless vehicle searches are valid, but probable cause is always required. Search of passengers' belongings are valid. We can also search the passenger compartments. We can search the trunks. Enclosed packages found in the trunks are also valid. I will tell you that's this gray area. It's a little sticky in real life. The book says it's valid. Great. But if there's no exigent circumstances and we have care, custody, and control of the vehicle and we think there's something major in there, I would always say, stay there, let's get a warrant, let's search it, and here's why. That way it can't be challenged in court. There is no authoritative decision on whether searches of locked trunks or glove boxes are needed. Searches of vehicles do not need to be made immediately. I can wait. You can go to jail. You can walk away from the car. If I want to get a warrant, I'm going to sit here all day with the car. I'll tow it back to the police department or the sheriff's department. We'll put it on the dock. We'll get a warrant and we'll search it in our time, not theirs. Warrantless vehicle searches are valid even if there was time to get a warrant. And because the cars are mobile, the courts have given us some latitude on that. The extent of car searches is governed by the objective reasonableness standard. Searches of motorhomes, this is interesting, are valid without a warrant because why? They're on wheels and they're mobile. Now there is some degree of expectation of privacy, but if we stop them on a traffic valid stop and we have to go in to talk to everyone, like a human trafficking case or they're smuggling stuff or it's like a party bus and even the driver's drunk, we can go in there and investigate. Now, a warrant is sometimes needed for the use of beepers to locate cars. I don't like beepers, but GPS devices. If I think the car's stolen, I may have to go to the company, produce a warrant to basically give us the information, especially if it's like a kidnapping case or if it's an unlawful restraint or child custody issue and the kid's in danger. We have to go through some hoops on that. Let's see here. We talked about warrantless seizures are valid, but not probable cause is required. Okay, plain view. Items that are within the sight of an officer who is legally in a place from which the view is made and who had no prior knowledge that the items were present may properly be seized without a warrant, as long as the items are immediately recognized and subject to seizure. Meaning if an officer is walking by a store and all of a sudden he looks in the window and he's just looking around and in plain view he sees marijuana or he sees child porn on the front of this guy's monitor. Or my favorite job I had when I was in graduate school is I used to teach scuba diving. And we go to Lake Tyler, we go to Terrell State Park, and even Lake Perky. Every now and then when we went down to 30 or 40 feet, when we're doing the skills and all that, we would see a car. We'd see a license plate. We'd see something discernible as a vehicle. My two standing rules were, number one, we don't open it because I didn't need a body floating out or something like that. Number two, just write down the plate. When we get up, we'll call it, we'll tag it with the balloon, and then we'll let the game warden or we'll let the sheriff's department know and see if the car's stolen or something's going on. And people are like, well, that's just weird. Don't you want to get in there? Well, my theory is if they're dead, they're not going to be any deader later. Number two, if you don't understand anything about physics, if a body goes up too fast, it will pop. So we want to preserve the crime scene, especially if we don't know anything. I just don't want people touching stuff. Now, 3 requirements for plain view. Number one, awareness of the item must have been through the sense of sight. I have to see this item. Okay, it's a stolen car. It's a stolen computer. It's a stolen piece of machinery. It's a wanted person or something like that. The officer must be legally in a place from which the item is seen, driving in a car, on the street, working, whatever. It must be immediately apparent that the item needs to be seized, meaning that I'm here, it's bad, it's illegal, it's stolen, I need to grab it before they either take off with it or destroy it, or it could be moved and I may lose it later. We're good to go. Now, the inadvertence is no longer a plain view requirement, meaning that if I was there just, under circumstances, meaning that, we're there investigating a dispute, a noise complaint, and then we start kind of looking around, and all of a sudden we see something in plain view that was, stolen, or we believe to be stolen, or we got a report of it being stolen, we wouldn't have to back out and get a warrant because we had a legal reason to be there. Plain view applies to open spaces and to motor vehicles. Just because you have a car, you have these great things called windows. Hopefully they're not broken or cracked. But I can look through the window. There's no expectation of privacy there in a motor vehicle. All right, open spaces, your backyard, if you own property, field, even this campus, it's open. All right, there's no expectation of privacy. Plain view applies even if the mechanical devices are used, like x-ray machines, like if you're going through the airport or if we have to have something scanned. What we can do is we can bring that in, and if they voluntarily are there or we have a legal reason to basically scan something and we think it's dangerous or might pose a danger to the general public or the officer, we're good to go. Now, I mentioned open fields a minute ago. Open fields are items that are in open fields are not protected under the Fourth Amendment, like a car in the middle of a field, an abandoned barn or shed or something like that. However, we have this term, if you guys remember, called curtilage. And remember this, please, it's important. The area to which extends around the intimate activity associated with the sanctity of a man's home and the privacies of his or her life. Meaning that curtilage could be the garage or workshop that's not attached to the house. If you live on a farm and you have your house, your garage, or carport or whatever, but 50 yards out you've got a barn, and that barn is holding your farming equipment, holds your cattle, and you're constantly using it, and you have an expectation of privacy, that would fall under the definition of curtilage. Now, to test to determine curtilage is simple. If a person having reasonable expectation of privacy in that place, and it is a part of the curtilage, it is protected under the Fourth Amendment. Application basically means that aerial surveillance of curtilage is valid. An area may be an open field despite there's a locked gate on the ground or there's a no trespassing sign. But if you've got like a drone or something like that, and police do it all the time, we're looking for marijuana plants, we're looking for human trafficking, smuggling, people dumping stuff in an open field, stolen property. We're able to take a drone and fly over and do an aerial shot, and we see it. Then we can decide if we can go out there, if we need to get a warrant or something like that. Abandonment, we talked about this too. When is something abandoned? Giving up a thing or item absolutely without any intention of coming back for it, or any limit without limitation as time is technically abandoned. All right. Factors in determining abandonment for the court basically is property left in an open field or a public place and you've walked away and just left it there with no intent of returning to get it. Property left in a private premise like an apartment or house. This depends if the occupants have left the premises and they're not coming back, or if we go in there and we look and everything's been cleaned out except the stolen stuff or drugs and all that. A reasonable person would be like, well, there's no furniture, they have the water turned off, the electricity's turned off, they're gone. Trash or garbage, depending on where it's left. Trash, if you have a trash can against the side of the house and it's on the property or in the curtilage, that's not abandoned. Now, if you drag it out to the street on Monday or Wednesday or whenever your trash pickup day is and you put it on the curb, the minute it leaves the property and hits the curb and is facing the street, that's abandonment. The intent to abandon is determined by what a person does with it. If they're walking through like a courthouse or like a mall and they throw stuff in a trash can, and let's say we want DNA or it's evidence or something like that, the court's going to say, well, he threw it away and he kept walking or she kept walking. Would a reasonable person believe that that person abandoned that property? And the answer 9 out of 10 times is going to be yes. Abandonment of motor vehicles. We like finding abandoned vehicles. There's just a trick to them. We have to determine if the vehicle is in fact abandoned. And we talked about this. Number one, there's 4 things we look at. Number one, flight from the vehicle. Meaning, is somebody just stole this car or has the engine running? Are they coming back? You get up to a car in the middle of 3 or 4 in the morning and the doors are all open. Were they going out for a joyride? Are they breaking into a house? You have to investigate that. Where and how long has the vehicle been unattended? If you're going up and down I-20, I-10, I-30, whatever, every now and then you'll see vehicles and they've got these bright fluorescent stickers. That's DPS's polite way or the Sheriff's Department's polite way of saying, hey, your car has been deemed abandoned. It's been here for a couple days. They put the date, they put the sticker, the date that they're going to return and check on it. If it's still there, the vehicle's abandoned, they're going to tow it. The condition in which the vehicle is left unattended, has it been there for a while? Is it on cinder blocks, whatever? And then denial of possession or ownership of the vehicle, where I go to a home and say, hey, I found your car. Man, that ain't my car. I said, this car with all your dope in the back? No, that ain't mine. I don't know whose it is. I sold that car. To you, I don't remember its name. All right? They'll deny possession of it. Cool. So now if I don't have an owner, can I seize that vehicle? Absolutely. Let's see. Border searches. This is a hot topic right now in Texas with House Bill 4 and Senate Bill 4. But the Fourth Amendment protections do not apply in immigration borders, particularly at the point of entry. If they are before our borders, there's no Fourth Amendment. But once inside the border, they cross over, some protections are afforded to that person. Now, the suspicious disassembling of a tank of a motor vehicle at the border is also valid because why? We know drugs get smuggled in gas tanks. We know people hide in between the bed and the base of a truck. We know that people get creative, so they can be searched. You don't need a warrant because they're illegal. They're coming into the country, and we're trying to make sure they're not bringing anyone in here illegally or any kind of illegal items. Vehicles may be stopped at fixed checkpoints and their occupants questioned and taken out of the vehicle. The search of vehicles away from the border needs a warrant or probable cause. So the further they get into the borders of the United States, whether it's Texas, Arizona, California, or whatever, the further they get in, the more gray area that we should get a warrant because they made it through a checkpoint, they made it through the border, whether legally or illegally. Now they're on our sovereign soil, we need to get a warrant. We talked about lineups real quickly, and we know some of the lineup laws have changed in Texas, but a police identification, procedures in which a suspect in a crime is exhibited along with the others with similar features before a victim or witness to determine if the suspect committed that offense. So back in the day, you'd watch TV and you see like 5 guys or 5 women lined up together and they all look reasonably the same. Well, there are some rights that they have. They have the right to a counsel there. They have the right to have a lawyer look at the lineup to make sure it's fair. You don't want like, if it's one guy and you got 4 women there, that's not very fair at all. The right to due process. They have the right to protection against unreasonable searches and seizures. That does not apply. All right? If they have a tattoo and the victim saw a tattoo or the witness did, they can roll up their sleeve, they can take their shirt off, there are things they can do. The right against self-incrimination, meaning that, let's say it was a sexual assault or a rape and it was dark and all the victim could remember is that he said a certain phrase, and I'll never forget that voice. As long as all 5 or 6 or 10 of them read that same line or say the same phrase, that is not self-incrimination. That is an attempt to identify a potential suspect. So there's no protections there. And then finally, we get into Miranda warnings. All right, now this came from the historic landmark case, and I promise you need to know this one, Miranda versus Arizona in 1966. Now, I'm going to read the Miranda warnings, and you've heard this a million times on TV, and if you're in law enforcement, you probably read it to a few folks once or twice. But the Miranda warnings go as this way. You do have the right to remain silent. Anything you say can and will be used against you at your trial or in a court of law. You have the right to have the presence of an attorney. If you cannot afford an attorney, you will be an appointed attorney prior to and during any questioning, and you have the right to terminate this interview at any time. So if they have an attorney and they don't want to talk to me, they can say, nope, I want to stay quiet. I want my attorney. We stop talking to them. I know in TV sometimes you see like, oh, they keep trying to trick him and all that. This is real world. We do not play with Miranda. Forever, we used to ask ourselves, well, let's say your suspect invokes his Miranda rights and stays quiet. How long is Miranda good for? Well, very recently, the U.S. Supreme Court said for 2 weeks. We can go back and ask this guy again if he wants to talk to us. He says, nope, I want my lawyer. I'm not talking to you. Take off. Cool. We wait another 2 weeks and we'll go back. All right? So the question we have in our agency and in this line of work is, when is Miranda needed and when is Miranda not needed? Very simple. Miranda is needed if that person is not free to go and they are basically going to answer questions that could incriminate themselves or basically get them, I don't want to say affiliated, but becoming a part of the offense of a known crime. All right? In other words, if this person believes that they're not free to go, they can't walk away, they possibly need a lawyer, they need to have the Miranda warnings read to them. They also need to understand that they can terminate the interview at any time and ask for a lawyer. They can basically, they know they're in trouble. When I don't need Mirandas, I might have a suspect, but I don't have enough to arrest them just yet, so I come in for an interview, or me and the suspect are having a cool conversation about something, and they are free to walk away right now. I have nothing to hold them on. I can't detain them, can't arrest them. I just got to keep building my case until I call them in. We have that Miranda warning discussion. I have my arrest warrant, or I get them into a confession, in which case I arrest them on scene. So, like I said, this was a lot of information. All right, please go back and review those cases. If you have questions or need anything, reach out to me. All right, as always, I'm here to help you. I'm still up in the College of Arts and Sciences, room 236 upstairs, unless they move us later this semester. But if I can help you in any way, shape, or form, please reach out to me. I'll be more than happy to talk to you. Good luck and congratulations on your graduation.